I'll call the meeting of the Committee of the Whole to order at 6:01 on happy February 2021. And I'll hand it over to the clerk at this point.
Yep, so this is a teleconference meeting of the Committee of the Whole. The President or Trustee Stokerbrand will be leading the meeting as President Rosick is absent this evening. Citizens will have a chance to talk after they have gone through and had their discussion. And tonight we will have a presentation led by Attorney Claire Silverman of the League of Wisconsin Municipalities.
And I would just like to thank Ms. Silverman for being available to help us learn about this. And I'm grateful that she could be here. And so I think, as I understand it, we'll go through her PowerPoint. And Ms. Silverman, my understanding is we can ask questions as we go. That's your preference?
Yes, I'd like it to be more engaging. So feel free to ask questions as we go.
And do you have the raise your hand function, or what? If we do this, is that preferred method to get your attention for a comment? Or
I think that would be fine, or just chime in.
Okay.
I'm not sure how I'll see the hand. I think I will, but you can just chime in.
Okay, thank you. And the intent at this point is to leave this open for a discussion among trustees, staff, and Ms. Silverman. So we're going to start with that protocol, please. And so let's see, is Jessica on yet? I know she was.
She is not. So we have Trustee Bockhorst present, Trustee Amenta, Trustee Ursink, Trustee Warren, Trustee Stokerbrand. President Rosick is absent, and I know Trustee Carpenter is going to be a few minutes late.
All right, I think we could probably, let's give it till, you want to give it 2 more minutes? So should we start at 6:05? Ms. Silverman, if that's okay with you? I think some of this might end up at the JP&L committee, which Trustee Carpenter chairs. So I would hope that we could give her the benefit of a couple of minutes here. Thank you.
Everyone dug out?
You can call it that. Whatever's really critically necessary. Like the mail carrier. We have 4-wheel drive vehicles, so.
Well, you know, my recycling sits alongside my house, and so it doesn't get it's like a pathway on the lawn. It doesn't get shoveled, so I don't know how I'm gonna get my recycling out tonight. It's like buried in 2 feet of snow. It's going to be like right after this meeting, I'm going to wrestle with my recycling cart for about 20 minutes.
You got to get Pablo trained with a shovel. Me too. I need to teach my dog to shovel.
We're getting a new little beagle at the end of the month, so we're going to have 2 of them.
Ooh, awesome. Okay, I think we should go ahead and start, please.
All right. Claire, whenever you're ready, go ahead.
Sure. So I just want to thank you for asking me to be here this evening. This is a topic that is near and dear to my heart. My undergrad was in journalism. And so I really love the open meeting law and the public records law, and these sunshine laws are so important to our municipalities. And so when I went to law school, I didn't know that I would get to be teaching them, but I'm thrilled to have them as part of what I do. So we could, you know, have a half-day seminar easily on the Wisconsin's public records law. I've tried to give you the great quick tour and just hit on the highlights. Again, I would love to hear your questions, would love to have this be more of a conversation. So feel free to chime in anytime you have a question. Obviously, I am not your municipal attorney, and I am not in a position to give legal advice. With that caveat in mind, I will get started. So I just want to give you an overview. We'll talk about the policy and presumptions, some important definitions within the public records law, sufficiencies of request, how to analyze requests, responding to requests, costs and fees, and enforcement and penalties. And I do know you're interested in enacting a policy regarding the public records law. And so what I would say is that the public records law actually provides a lot. And so in enacting a policy, I guess I would urge you to think about what the public records law does not do for you that you want to do in your municipality. So basically, the public records law allows any requester to inspect any public record that's being created or that's kept by an authority. And you can see that there are those terms underlined, and that's because those are defined terms, and we'll take a look at them. So any requester can inspect any public record created or kept by an authority, except where either a statute says disclosure is not allowed, or common law, so court-made law says you can't disclose, or the balancing test indicates that disclosure is either required or justified. And in certain instances, the law affords greater or lesser rights. So for example, the definition of requester does not include incarcerated persons unless they are asking about records particular to them or their minor children. Sometimes people have a greater right of access if the record contains personally identifiable information about them. And the reason we have the public records law is because we have a representative government. And so we need the electorate to be informed about what their public officials are doing. And when they go to the ballot, they need to know, what their officials have been up to so they can make informed decisions. And so based on that, the legislature has given a very strong declaration of legislative policy and saying that the public's entitled to the greatest possible information regarding affairs of government and the officials or officers and employees who represent them. So we start out with the premise that the public is entitled to the greatest possible information. And the legislature also says that the law shall be construed in every instance with the presumption of complete public access, but it modifies that's consistent with conduct of public business. So access is not absolute. The legislature has recognized that there are times when it's appropriate for public records to be kept from disclosure from the public. But we do start with that presumption of public access. And the legislature says that denial is generally contrary to the public interest, and only in an exceptional case can access be denied. So an exceptional case will be where you have a statute that says you can't disclose, or where there's court-made law saying you can't disclose, or where a custodian decides that the interests are such that when balanced, that the public interest requires non-disclosure, that weighs in favor. But the legislature has also said that providing records is an essential and routine part of duties. So it's not something extra. Sometimes it feels like extra when employees and officials have to respond to records requests, but the legislature has said it's part of your routine duties. So the effect of that presumption is that the scales are already really weighted very heavily in favor of disclosure. So when the custodian is weighing a request, they have to remember that strong presumption in favor of disclosure. The terms are defined. I remember back fondly to my younger years when records were those round things on the top right, and it was less complicated. But records defined within the statute very broadly any material on which written, drawn, printed, spoken, visual, electromagnetic, etc. information is recorded or preserved, regardless of physical characteristics, which either has been created by or is being kept by an authority. So
can I ask a question?
Yes, please.
When was this law written, and has it been updated? I mean, when I looked at the statutes, it was like 1980 or something. Has it been updated since then?
It hasn't been updated very much. You know,
and when was it originally enacted?
Well, I know that it was modified, I think 1981 or 82, I believe. But I think, I want to say maybe in the 70s. I don't know the answer. I don't.
So the most recent law is like 40 years old.
Yes. And it really hasn't been updated. And because of that, you know, technology has changed so much that there are so many questions. So. But because it's defined so broadly, it's helpful to know what the definition excludes. And it does exclude purely personal property that's unrelated to the office, published material that's available for sale or at the library. And then if somebody has drafts, notes, or preliminary documents and computations that they've prepared for their use, then those are not considered records. Also materials with limited access rights. Now drafts doesn't mean that it's not, you know, finalized or perfect yet. It just means that it hasn't been distributed to those for whom it's intended. So.
Just to back off of Trustee Amenta, you know, and you may get into this a little bit, but you know, so for instance, you know, Facebook and today's newest technology, is that a gray area for open records? I mean, if I'm talking to somebody personally on a, you know, some sort of messenger, is that an open records? Is that classified? Could be called an open records?
Well, okay, so you said you're talking personally, and is it about village business?
Just hypothetically, you know, I mean, it could be about village business. Sure. It could be like, sure. You know, tonight we're talking about, you know, open records, you know, what are your thoughts on open records? So let's say I hypothetically throw something like that out there. Is that subject to open records? And then how would the person requesting those open records know to look in my messenger? And I'm just curious, because there's such a gray area of you know, with today's technology.
Well,
too, how would you know that what someone presented was a factual record?
What do you mean factual record?
Well, I mean, like if you get something from the village of Shorewood, it sort of implicitly you would think it's a official record. I just wonder, with new technologies and social media, different platforms, is it possible that something could be about village business, but could have been manipulated?
Yes, but then you probably wouldn't have a copy of that record, or, you know, somebody could purport to be doing something on behalf of village of Shorewood, and it wouldn't be, you know, a record that the village would have. But given the definition, you know, Facebook Messenger would definitely be a record. And I think if it's within your official responsibilities, then yes, you know, it is considered a record. And so part of the difficulty is, you know, how do you retain those things? And sometimes municipalities have created, you know, at least for email, things like that, ways to retain what officials and employees send out. And so those can be captured. But when you're talking on, you know, another platform, then it's harder to know how those things are captured and how to retain them and deal with the obligation to retain them. But yes, those things, all sorts of things would be records, like, you know, audio, video, web-based, you know, even information like on your cell phone, like texts. And so it's the content and not the location or the medium or format that determines whether something's a record. So electronic records, you know, that doesn't determine it. A lot of times people will say, well, I was doing this on my personal computer or my personal phone. Nonetheless, it's a record if it's connected with your official responsibilities. Similarly, you know, if you make a grocery list and you're using your computer issued, you know, if the village issues you a computer and you're doing email from your village address, then that grocery list technically is a record. It fits within the definition of record. It's not really related to your official responsibilities or duties. And so probably it wouldn't be subject to disclosure. But the fact that it would be on the municipal's server would make it a record, but maybe not subject to disclosure. So I think it's important for people to be aware that the use of their personal devices doesn't necessarily insulate something from being a record. And I think my understanding is that your municipality has created something which captures the emails and records, in which case that's very helpful to you as local officials.
Thank you. And I'm sure it'll dig deeper, but I appreciate that. Thank you.
Sure. So another definition that we had in there was authority, and that's defined as any of the following having custody of a record: state or local office, elected official, agency, board, council, commission, etc. So you as elected officials are considered an authority within the definition of the law.
Can I ask a question? If you could go back to that slide, is that all appointed? So anyone on a board, but anybody who's appointed as well by the board?
It does clearly say elected official, but it also says a local office. So I think you'd have to consider if something's a local office. And if it is, then yes, I think they would be considered an authority. Now, maybe, you know, if you have a committee that's set up with some citizens, they might not necessarily be an authority because a committee might not be a local office. So you'd have to look to how your village defines local office.
So for example, the Plan Commission or the Human Relations Commission?
They would be an authority.
And so a Facebook post from someone on the Plan Commission or the Human Relations Commission would be subject to open records?
Yes, I think.
Even if it's on their personal Facebook page?
Yes, I think so.
Well, as long as it's in the course and scope of their work for the Plan Commission or Human Relations Commission. I mean, it's I always view it as like a hats on, hats off approach. You always have to be within the course and scope. If you're not, it's not a record, you know.
Yes, thank you. And sometimes it's harder than other times to take your hat off. So it's easier for a Plan Commission member to take their hat off than for a trustee, for example. Yep. And then there are custodians, and those are the persons vested by authorities with the legal power to carry out their duties under the public record law. And so elected officials are custodians of their own records unless they've designated somebody else to be that, that custodian. Very often the clerk is the custodian. So it's not uncommon to have somebody designated as the custodian. And if there's not a specific designation, then defaults are the highest ranking officer and the chief administrative officer, if any. And chairpersons of committees are the custodian for the records of the committee, unless somebody else has been designated.
And this question is maybe for Sarah, but I'm assuming that, you know, we have default designated you as the custodian of records, as in we're not all our own custodians.
So if somebody was requesting a record, a trustee record, like through your email, I would get in contact you, and then we would work with IT to do that search. And then anything else, you know, that would pertain to anything at Village Hall, other than the police department. If it was not in my department, I would work with that department head, because I don't keep all of everyone's records in my office. But yes, it would probably go through me, and then I would work with the individual who had the record on hand. Okay, if that makes sense. And then police department, they really handle all of theirs on their own separately.
So it's more centralized model than for the village.
Correct.
And that's not surprising, because there are certain records that police need to keep confidential, and there are ongoing investigations that you wouldn't necessarily know about. So that's not surprising. If there were, you know, if you did go outside, for example, the village email or the thing that captures on the server, you would need to produce the records. You would be the custodian, and you would be the authority and responsible for producing those records if they weren't there in a way that the village could capture them. So just talking a little bit about sufficiency of request. Request does not have to be in writing, it can be oral. And the requester doesn't need to identify themselves or what they want the record for or what to do with the record. So there's no specific form required and no magic words required. So for example, if somebody gives you a request for a record and it says that I'm asking for this under the Freedom of Information Act, even though the Freedom of Information Act is a federal act and doesn't apply to the state of Wisconsin, you couldn't, you know, refuse their request or not respond to it because they said Freedom of Information Act. A record has to reasonably describe the information that the person's seeking and be reasonable as to time and subject matter. And it can't so burden the custodian that normal office functions are impaired. So it wouldn't be reasonable or sufficient, a request, to ask for somebody's hard drive. You know, it has to be limited as to subject matter or subject matter, date, and just because there are a large amount of responsive records doesn't mean that it's necessarily an overburdensome request or that it's overbroad.
Claire, I have a question.
Yes.
So for me, it doesn't seem like a big request to make it be written. Because if you want documents, I mean, it just that it can be oral. So if we didn't have COVID and someone came in and said, I want to see someone's filing papers for an upcoming election, then they would just produce them if someone was available. I'm assuming someone is. But I just wonder, in the times of the written or oral, that's part of state law.
Yes.
It does seem extremely generous.
Yeah, and requesters need to put their request in writing in order to have certain rights. So in order to appeal a decision, they need to put their request in writing. And then once they've done that, then the response has to be in writing. But initially, a request can be oral and somebody can call up and ask for something. And that's sufficient under the public records law.
Thank you.
So in terms of responding to requests, the law doesn't require that somebody respond within 5 days or 7 days. There's no certain time, but the wording of the statute is that the response should be as soon as practicable and without delay. So Department of Justice has taken the position that normally 10 working days is a reasonable amount of time to respond. That might be too long if there's nothing else going on and you're just sitting on a request, but they take the position that that's normally reasonable. And since they're the ones who do enforcement, I think it's important to know that. But what's reasonable really depends on the nature of the request. I mean, are they really asking for a large volume of records? How, you know, what kind of staff do you have to process the request? What else is going on at the time? You know, is the clerk involved with taxes and something else that's demanding their attention? So there are a lot of considerations that go into determining what's reasonable.
Just out of curiosity, has there been any litigation placing outer limits on what's reasonable? I'm curious as to whether, they've ever ruled that, 60 days is unreasonable or 90 days, just so we have kind of an idea of scale.
I'm not aware of any bright line, because it's always very fact specific and depending on what's going on. But I would say that if response is going to exceed 10 working days, the best thing to do would be to reach out to the requester and let them know you're working on it, or just send them an email or something to let them know why the request is taking longer than they might anticipate.
A placeholder email.
Yeah. All right. In terms of format, requesters can request records in a particular format, but the custodian doesn't have to create a new record for them or put an existing record in a particular format. So for example, there was a request this is a case that was decided, and it was for a 911 call, and somebody had requested, and I'm not proficient with technology, either digital or analog, and one was available, but they wanted to convert it to the other. And the court said, no, if the record exists in analog, then you give it to them in analog. So if they request it and it is there in that form, you need to give it to them in that form, but you don't have to put it in a particular format for them. In terms of responding to requests, I think it's really important to give very high priority to requests if there's arbitrary and capricious delay. So without reason, that would expose the custodian to punitive damages and a $1,000 forfeiture. And so it's just really important not to put a public records request to the side and forget about it. And when denying a request, it's really important that the reasons be specific and sufficient. You can't just draw legal conclusions, like it's not in the public interest to disclose this information. You have to explain why. And if you're denying a request, you have to inform the requester that that denial is subject to review in a mandamus action. So. And you can't give blanket reasons, like we don't allow those kinds of records to be given out. You have to give specific, sufficient reasons, unless there's statute or something that clearly says you can't disclose the record.
So quick question, that mandamus action, is that, I'm assuming that's a county district court where it would go? You bring almost like a TRO? Like an immediate.
It goes to circuit court.
Circuit court, okay.
Yeah. And so I think it's really important for the custodian to ensure that they understand the request. And if not, they should seek clarification. And so the first step in analyzing the request is to ask whether there are responsive records. And sometimes the knee-jerk reaction is to just say, to deny a request. And there was an assistant attorney general who would tell the story about this long case. It was just a saga. It went on and on and on. They denied the request only to get to the end, and the court said, you have to turn over the record. And it turned out there was no record. And so that's not a good thing. So the first step is whether there are responsive records. Again, the authority is not required to create a new record. They don't have to extract the information that is there and create a new record. So if the answer is no, the requester should be informed. And then if the record does exist, the question is whether the requester is entitled to access. And if so, you consider the general right to inspect the record. And if that right does not exist, then again, somebody might have a greater right to access because the record contains personally identifiable information that pertains to them. And so requests will fall into one of three categories. Either there will be absolute right of access allowed by statute, and there aren't that many instances of that, but one would be uniform traffic accident reports. Case law says that, that there's right to the police blotter or the daily arrest log. And then there might also be an absolute denial of access. So a situation where statutes or case law prohibits release. For example, it might be records pertaining to juveniles unless certain circumstances exist, or records that are the subject of a current investigation. And then access also can be determined if you don't have either absolute right of access or absolute denial of access, then access is determined by the balancing test. And that, in that instance, the custodian has to weigh the public interest in non-disclosure against the public interest in disclosure. And if you remember, the scales are very heavily weighted in favor of disclosure. And the record subject's private interest is really not what's considered, it's the public interest. So public interests favoring non-disclosure can be found in statutes or case law. And then I have some examples like privacy and reputational interests. Other examples are exemptions to the open meeting law. And those are just indicative of public policy. They don't mean that you can't release something, but those are indications of situations where you might not want to release. So things pertaining to personnel or things that come within the exemptions. But it's always determined on a case-by-case basis, and it's very fact-specific. So again, you can't just have a blanket exception. And one area where this comes up is frequently, if complaints by citizens, you might, under the balancing test, say the public interest is in favor of non-disclosure, but you can't have a blanket exemption saying that we never release complaints or information about persons who made the complaint. And if a record contains some information that can be released and some that can't, then it's incumbent on the custodian to separate the information. They have to disclose what can be released.
Is there any kind of safe harbor there? As in, like, if the custodian accidentally releases information they should have, are they still going to be liable? Or is it something where as long as they use best efforts, they're not liable for what they released?
It would depend on the specific facts. There might be potential liability. I mean, custodians are supposed to know the privacy laws. If they're acting in good faith, then they're not probably going to have personal liability. But like, for example, the Driver's Privacy Protection Act protects certain information that comes from DMV records. And if that's released, there is potential liability.
Okay.
So as I said earlier, oral requests can be denied orally, but written requests require written denial, and you have to list specific reasons and can't just state conclusions. And that's to show that the custodian actually thought about it and exercised their judgment. And the reviewing court is usually going to be limited to the reasons that were offered up as to why something couldn't be disclosed. So it's important in the initial disclosure to make sure that all the reasons are given as to why that cannot be disclosed if it can't. And this is something that I actually saw in the Attorney General's presentation, was that the availability of same records from another source is generally not a sufficient reason. In terms of costs and fees, authorities can recover the actual necessary and direct costs. So for copying, locating, if the location fee exceeds $50, and mailing. And you can charge, if you're copying, you can charge for the person who's making the copies, you have to charge the lowest wages for the person who can do that. So, and the costs that you can recover are those that are identified in the statute. So if a request requires that you redact a lot of information out, you cannot charge for that time. That's not statutorily authorized. And an authority can waive or reduce fees if in the public interest. And you can require prepayment if it exceeds $5.
Is there any, sorry to interrupt, is there any kind of attorney general guidance or anything like that on what is a reasonable fee for actual production of a copy? I know we're 10 cents. I think Milwaukee County used to be more than that at the courthouse, like 10, 15 or 25. So it almost seems like there are a lot of different entities charging a lot of different rates. Has there ever been anything as to what a rate for copying should be?
Well, the Public Records Compliance Guide used to advise that, you know, anything between 10 cents and 25 cents would be considered reasonable. 25 cents was a page was sort of on the outside of reasonable, but that was at the outer limits. But a couple of years ago, Department of Justice took a look at what it cost them to make copies, and they realized that they were charging quite a bit in excess of what it was actually costing them. So they issued an advisory saying that it's really necessary to be able to justify your costs. So, you know, it's important to look at, you know, what is your, you know, copy lease. If you're leasing a copy machine, you know, what does it cost you to make copies? What does the toner cost? What does the paper cost? What are the labor costs of the person? Again, you want to charge the lowest fee that somebody, right? So,
so I'm sorry. So like, what about like redaction? So I was looking at our fee schedule, direct hourly rate for research and compiling documents of other records not readily available, $18 to $44. So let's say an attorney does it for $200 an hour. Is that the kind of variety we could see here in pricing?
Well, you know, again, it's the actual necessary direct costs of copying. Locating can only be if it's in excess of 50 mailing. So I don't think you can charge, you know, for your attorney to review the records. But if the attorney is the only one for some reason, you know, maybe it relates to attorney-client privilege and they have to review records. In that case, maybe the attorney is the one who can review the records. But you can't charge the costs of redacting.
Clara, I have a question further on the redacting portion.
Mm-hmm.
So with redaction, sometimes you have to make multiple copies because the marker isn't dark enough to go through that you could hold it up to the light to see what was redacted. So you have to copy that piece of paper multiple times. Are you able to charge for those copies? That's always been a question that people don't exactly have an answer for.
Well, you know, I would say if you could cover the information in the first instance, like make sure that you do a better, I don't know, whiteout or whatever. I'd be careful about those kind of charges. If it's, you know, is it necessary, I guess.
Okay.
And that's going to be the question. Okay. There are some things, you know, if costs are really high, it might make sense to go back to the requester to see if they want to limit their request, or if the request could be clarified in a way that would reduce the costs. A lot of times there are probably included records that won't be of interest to a requester. And so it's good to communicate with the requester and see what exactly they're looking for and if it can be narrowed, and, you know, maybe that will allow a quicker response. And it's important to be prepared to support the costs. So you should have or the village should look at what it actually costs to make copies and then make sure that it's charging no more than that amount. Public records law is usually enforced by the district attorney. So if somebody has a complaint, they'll go to the attorney general or the district attorney. If the district attorney doesn't do anything, they can go to the attorney general. And if the attorney general is not interested, that person can bring an action for mandamus on their own. And that asks the court to review the denial and order the official or the employee or the authority to produce the record. And again, the request has to be made in writing before an enforcement action can be brought. So a requester who brings an action and prevails in whole or substantial part is entitled to receive reasonable attorney's fees. Attorney's fees, even when reasonable, you know, that can be pretty expensive. Damages of not less than 100 and other actual costs. And again, there is the opportunity for punitive damages if the custodian's denial was without any basis.
Can I ask about that arbitrary and capricious? So if the village were giving, in similar cases, granting to one person, but not responding to a similar request from another person, would that qualify as arbitrary and capricious?
It might. It would depend on why they're not responding to the other person. I mean, it really just depends on the specific facts. You know, I don't think the only conclusion would be, you know, that it's just arbitrary and capricious. But if they didn't have a reason for that, and if it was without basis, then maybe. So the Department of Justice has a really wonderful public records compliance guide that's available on their website. It's free. It's a PDF. It includes links to all the case law, all the attorney general opinions interpreting the law. And it's really a wonderful resource. So if you have additional questions, I know, again, this was sort of the whirlwind tour. You know, I would urge consulting that. And that is the end of my presentation. And again, if you have specific questions that I didn't cover, I'd be happy to talk to you. And so my contact information is on there. And I can send Rebecca this PowerPoint if you like.
I personally would like the PowerPoint, so I think that'd be a great idea. Do any other trustees have questions at this point?
I have some questions.
Trustee Amenta?
So if we have a database, for example, and let's say an Excel spreadsheet, and someone asks for data, and they ask specifically for source data. So, I mean, I guess, you know, a lot of the issues we've been having are having to do with not wanting, that people want to get the actual numbers so they can look at them and analyze them and move them around. So the question is, if we are keeping the data as an Excel spreadsheet and someone does an open records request for it, and we do a print it out, you know, and give them the numbers on a piece of paper, is there an obligation for us to give them a digital file of the Excel data as opposed to a piece of paper with numbers written on it?
You know, some of these issues involve the intersection of law and technology. And so the data that's actually in the spreadsheet is the record. Or, you know, it's not necessarily the computer software and the formats it's in that's the record. So a number of years ago, there was a big case involving, it was a company called Wire Data, which did assessments for municipalities, and it would dump all the assessment information in, but it didn't want to give out the software because it had a proprietary interest in it. And so in that case, people had requested an electronic copy and they were given a PDF, and the court said, well, that is an electronic copy, so that's sufficient in terms of what you, but if somebody asked for, you know, specifically the Excel file, you know, I don't know if that would be considered, you know, something proprietary that I would think you could release it in an Excel sheet. I don't know enough about the technology to answer whether that would be a problem, but the key thing is that it's the data that's put into the spreadsheet and not the computer software or the system that's the record.
So if the numbers were in a PDF, that's fulfilling the requirement. If it's not in Excel.
Not necessarily, because again, you know, in the wire data, the case that we know what the result was, it just so happened that the request was for an electronic copy and a PDF was an electronic copy. So,
did you say it was?
Yes, the court said it was. So it was within the request. But, you know, I can't, Excel is something that's so widely out there that if something's available as an Excel file, I can't think of why you wouldn't be able to give it out in that format. But I don't understand the technologies well enough to answer. So I would say that it's really the data that's entered. In some instances, it might not be sufficient.
Okay, Trustee Amenti, did you have a follow-up or another question?
Can I?
Yeah.
No, Trustee Carpenter.
Sorry, I didn't mean to interrupt. Can I ask a follow-up on your question, Trustee Menta? Is
yeah,
that okay?
sure. Yeah.
So the reasoning for requesting in Excel and then getting in a PDF sort of, I don't want to say it negates the data, but it's really difficult to understand any trends or, you know, how those numbers are all related. So, you know, is it, I guess, like, would a resident have to ask for their open records request to be in a specific format versus, you know, like I'm looking for an Excel spreadsheet of whatever numbers? I mean, is that, you know, then and then if it's in a PDF, then that's not sufficient? I'm just trying to understand, because I do think that the method in in how some of these documents are produced is a pretty important factor in the discussion.
Right, and actually, I mean, that was the case in wire data, was that people wanted to be able to manipulate the data that was in there, but, you know, the software was proprietary and was protected, and so the court said, no, you know, it's really the underlying data. And again, they skirted the issue because it was given as a PDF and an electronic format was requested. But if you had, you know, a Word document and somebody asked for the Word document, I think that would be the record. And there wouldn't, you know, I don't think anybody would really think twice about just giving it out in Word. But, you know, so maybe Excel is the same thing.
But potentially somebody would have to put all those numbers. If they got the PDF, they would just have to go and input all those numbers into a whatever, copy and paste, and put those numbers in their own Excel spreadsheet. And is that kind of what you're saying? Is kind of the direction that if the company has proprietary software, then they're getting a PDF, then that resident has to take all of that information and put it in their own Excel spreadsheet to figure out the trends. Is that kind of what you're saying?
If Excel can't be shared, yes, then I mean, they have a right to the data that was put in, but if they don't have a right to receive that data as a particular record if it doesn't exist.
So what I'm hearing is that we don't have the obligation to say turn over the Excel spreadsheet. We have the obligation to turn over what's populated within that spreadsheet. But we as a board, as a policy, could say, you know, anything in Excel, we're going to turn over, anything in Word, we're going to turn over. You know, what I'm hearing you say is the information is actually the record, and we can choose the manner in which we turn over the record, whether we want it to be static like a PDF or manipulatable like Excel. And we can choose the policy manner to say, if we have it in Excel or Word, it's going in Excel or Word, so our residents can then manipulate the data and it's more useful to them.
I think you probably could do that. But again, you know, if there's proprietary software or something that the village is using, I think you'd have to be careful about, you know, releasing that. So you'd want to work certainly with your municipal attorney to make sure that you don't have any problems that way.
But even if there's proprietary software, I mean, you can generally download data into a variety of formats. So you could download from Phoenix, for example, probably into Excel, or you could download it as text. You know what I mean? I mean, so I think it's one of the policy things we do need to consider. You know, like Wes, I thought Wes, that was a good distinction. Is it manipulatable or is it static? And that might be something we want to talk about it, because even if you're downloading from Phoenix or some other proprietary, you could download it in different ways. So, but I did also have a question. We've had a resident who brought his own scanner and wanted to scan copies of records. So, okay, my understanding is that a copy was made and the paper copies were available to him at the police station, and he wanted to use a scanner, his own scanner, to scan them. And is that allowable or not?
Well, I think the law gives the custodian the discretion to decide whether or not that's appropriate. And there's case law, I think, involving someone who brought a scanner, and the court said that the custodian did not have to let that person use the scanner. So they have a right to either copy or inspect the record, but not necessarily do it themselves. And okay. So
okay, and the other question I had to do with public officials. Okay, so I'm an elected official. I'm interested in seeing documents, any document that could be subject to an open records request. Do I have to go through the open records process, or can I say to the village manager, I'd like to see all your emails in regards to X, Y, or Z?
Well, I don't think that the public records law gives an elected official a greater right than the members of the general public to access public records. So, but I think typically municipalities, you know, if the governing body could have a policy, and as long as those records are subject to disclosure, you know, could say we don't want our elected officials to have to go through the public records law. But I think if in the absence of such a policy, again, I don't think officials have a greater right than the general public to see records unless they need them to do.
Yeah, how can we do our job if I can't email the finance director and ask him for what?
Right, as a village board, you know, you would have that ability, but as a single, you know, official, I don't think you necessarily have the right to all records of the village.
I don't understand what the difference is as a village. Oh, because I'm only one member of the village board.
Correct.
So if I have a question about, for example, as I did for today's meeting, about specifics of bond counsel's advice on being able to use proceeds from one issue to a different one, I don't know, that just seems something that we definitely need to include as policy, because public officials have questions all the time. And it's happened where we have a legitimate question about village business, not the current village manager, but the prior village manager refused to share documents with us. So, but you're saying that as a village official, I do have to submit an open records request if there's another official or the village manager who refuses to share documents.
all I'm saying is that I don't think the public records law gives an individual official a greater right to access public records than the public. So your village board could decide how it wants to handle that as a matter of policy. But the public records law does not give individual officials a greater right.
Okay, thanks. That's all I have.
Okay, thank you. Any other trustees have a question? I have to say I'm still confused by the making a copy issue. So I believe Ms. Silverman, correct me if I'm wrong, you had said that the custodian can decide about, so let's say if I stood there with my iPhone or I had a portable scanner, the custodian can decide the data, again, it's the data that is being made available, but, and I don't get to choose how I make my copy? The custodian gets to decide?
Yeah, I mean, you don't necessarily get to decide how you make your copy. The custodian is the one who has the responsibility to safeguard records. And so I think they can decide unless, you know, maybe, I guess the village board could decide, you know, I don't think it could allow someone to use their copier to access a record that might be damaged. But yeah, I think the law gives the custodian discretion to decide, you know, how to handle that. You know, if you wanted to take a picture of a record with your iPhone, I think it would be hard for someone to argue that that would somehow damage the record. But, you know, I think the custodian's the one who's responsible for protecting the record.
Okay, thank you. Anyone else? I would just like to say, if you see trends with technology and open records and policy going forward with municipalities, what kinds of things do you see in terms of what are municipalities doing, Ms. Silverman?
In terms of what specifically?
Setting policy and operations, village operations.
To be honest, I haven't seen a lot of municipal policies. I think municipalities are making an effort to capture municipal records. So for example, you know, ensuring that, you know, officials are given a municipal email that they can communicate with people and that those emails are captured by the municipality. And I haven't surveyed municipalities, but I haven't seen a lot of policies.
I would think, considering that we're all in a lot of local news deserts, this is only going to increase. Okay.
Can I ask one more question?
Yes, Trustee.
Sorry, Trustee Amento was actually ahead of me, so.
Okay, Trustee Amenta?
No, I just want to say, I mean, you started the presentation saying we probably it was unlikely to need a policy because the open records law was, the presumption was so clearly on the side of providing records. And yet, but I mean, we've come up against a number of situations where the open records law does not provide direction or it limits. So I think it's a little bit contradictory. I guess I just have to say I don't agree with the statement you made at the beginning of your presentation.
I didn't mean to imply that your municipality doesn't need a policy. I just meant to say that you know, the public records law provides broad protections to the public, and in drafting a policy, you should think about how it's not serving you. So I did not mean to say that you shouldn't have a policy to address those things that, you know, the village thinks need to be addressed.
And I want to build on Trustee Amenta. Actually, I think this is probably the first question she asked. which I think is a good one. And I just wanted to ask, so I'm looking at the statute. I have it pulled up on my other screen. Looks like it was an action 81 or 81. Looks like there are amendments every couple of years. I imagine they're minor amendments. I imagine there's a lot of administrative stuff. Just wondering, given how the statute's worded and 1981 terminology and all the things we've discussed here tonight, has there been any push from anywhere to just go through, overhaul, and update this statute to bring us into the digital age? I mean, this is 40 years old. So, it seems like something that could be worked on in a bipartisan effort, even in a hyper-polarized time. So wondering if there's been anything out there to try to update this.
Yeah, no, we have suggested that the legislature take a look at this and that it issue guide, that it revamp it to take consideration of all the technologies. And the legislature has not wanted to touch it. We agree. We would love for it to be clarified.
So no traction at all at the state level then?
Unfortunately, no.
Trustee Stoker, I have a question, and then building off of Trustee Warren's as well. The municipal clerks have been pushing for that as well, to change the open records ordinance, just because it does not meet with the times anymore, and it does make it more complicated. When you're the custodian of the record, and then law doesn't really specifically talk about those pieces. But one question, as far as if somebody submits a record request and there isn't such record, but it really is a question, and you could answer that question. Do you answer that question? Do you say there is no such record? So I manage a customer service department, and half our, most of our job is to answer people's questions during the day. So that individual could call the front desk and ask that question and we would answer it. But because they're submitting an open record, there isn't a record per se, but it is a question. How do you handle that?
That depends. I don't think there's any correct answer. Okay. Customer service, providing that information is great if you have the time and the availability and the resources. But if somebody's requesting it under the public records law and there's no such record, then I think the answer is there's no such record. And somebody might want to say, well, you know what? I know where that information exists and I'd be happy to put it together for you, but the law does not impose that obligation.
Okay, we have done in the past, there is no such record. It is a question, so the answer to the question is this, if we're able to answer it, in a relatively quick time frame. So, okay, thank you.
So is that sort of a situation where there's not a record, but there's general knowledge about it? Is that sort of the nuance there?
Correct. So say somebody, I'll give you an elections one. If somebody could have the process of how we handle absentee ballots in our office, right? We don't really have a written policy, but we do a process. So I could share that simple process and answer that question. But there isn't a written policy that we hold in our office to say this is how it's supposed to be done when you do in-person voting. Does that make sense?
Yeah.
Yep. Okay.
Thank you. And I guess, as Claire mentioned, Ms. Silverman mentioned at the beginning of her presentation, the goal would be to err on the side of giving out information that can help people. So even if it's not written down, I mean, I can see the situation where you might say, I want to check with the department head before I release that, explain that to you. Or maybe you could direct them to a department head. That's just would that be an appropriate response too?
Yep.
Okay. Any other trustees? Okay, I see there's a hand in the public. If the trustees have no further questions, we have a little bit of time. We'll take a comment. Clerk Bruckman, please.
Yep, Jeff Davidian, if you would like to unmute yourself and state your name and address, and then you can speak.
Jeff Davidian, 4101 North Prospect Avenue. the village attorney of Shorewood is a contracted vendor, but also an employee and an official, since that office is created in the ordinances. The records of the village attorney then are subject to the village retention policy, or is it the attorney-client privilege, or excuse me, the records are the property of the village and the attorney cannot dispose of them without the approval of the village, of the client?
Yeah, that's a difficult question. I mean, I don't think that the records of the, you know, an attorney that's in a private law firm, I don't think those are the property necessarily of the municipality. I mean, I think records of officials who contract with the municipality are subject to the public records law, certainly. But whether those records are subject to release would have to be, you know, analyzed. It depends on specific records. What kind of records we're talking about.
The Office of Lawyer Regulation, or the Supreme Court rules, say that an attorney has to turn the files back over to the client when the employment is terminated. The attorney, a village attorney, is employed by the village. The village is the client. So is there a distinction between the records of a municipality as a client of a private attorney than if the client was something other than a government entity?
I have not looked at or considered that issue, and I don't know the answer.
Can a village attorney throw out records of, okay, if you haven't considered them, you haven't considered them. You said earlier that if somebody pulled out an iPhone and wanted to take a picture of a record, you'd be hard pressed to deny somebody the opportunity who made a public records request to take a picture of a copy of the original, not the original itself, but the copy. There'd be no threat to the original if you only are taking a picture of a copy. Is that correct?
Again, you know, it's totally fact dependent. And so I don't want to say there would never be a situation, but if somebody is being allowed to look at a record and they would be allowed to have a copy of the record, then I don't know why it would harm the record, the copy of the record, for that person to take a picture. But again, I'm not the custodian. I've not been asked. I'm not, I don't have any facts about the specific record, so I'm not in a position to answer. But yeah, I think it would be hard to justify or to say that somehow the record would be harmed. But maybe they would. Maybe they could. I don't know what the basis would be.
Is it if the custodian has the authority to give records to one person in one format and then to tell another requester that they have to take it in another format, is that an arbitrary, unfettered discretion that discriminates based on the whim of the custodian? Or does it have to be the same for everybody?
No, I mean, the custodian has discretion of the public records law. I don't know what, I mean, the facts would need to be laid out. I can't answer a question like that. I'm sorry.
Okay, thank you very much.
Sure.
Thank you.
Just to follow that up, Ms. Silverman. So let's say a resident makes several open records requests and just doesn't want to pay for copies anymore. Can they just go with their iPhone and start taking pictures of all of that to save money?
You know, if the records have already been made, or if the request has already been answered for that person and, you know, they need to pay to get the records that were requested, then, you know, I don't think they should necessarily just be allowed to take pictures. And I know a lot of municipalities have had people who request, you know, they make these big requests and then they don't come in and pick them up. So there's a lot of time and material expended on behalf of the public answering requests. And, you know, then the municipality doesn't get repaid for that. And, you know, they can require prepayment if it exceeds $5. So yeah, I don't think, you know, if somebody requests records and the request is prepared, then I don't know that, you know, I think the municipality could require payment before allowing people to take, before delivering the records, I guess, if it's in excess of $5.
Any other trustee questions? Seeing none. Thank you again, Ms. Silverman, for your time.
My pleasure.
Thank you.
Thank you.
Very helpful.
All right, thanks.
Thank you so much.
Okay, moving forward, is there a discussion about how to move forward with this? I think JP&L, this came from Trustee Carpenter's committee. Do you have ideas or want to lead a discussion on how we should move forward based upon what we've heard today?
Yeah, you know, I think for me, the biggest takeaway is really that we have some technology updates that I think are sort of most mission critical to our open records requests and our abilities to fulfill those requests, which I think is making Sarah's job even a little bit more difficult. So I think maybe that's a good place to start the discussion. I'm going to close the door. So sorry, a lot of background noise in the meantime.
Okay, thank you. So is that something that we'd like to get input from staff? I wonder if, so the way I see it, it's Sarah and Diane, Clerk Bruckman, Assistant Clerk DeWent. We've got Director Bart. I believe he has to fulfill some open records requests, and the police department, obviously. I wonder if this is something that we would like to get some staff input on besides our policy discussion. I mean, I'd feel better if I knew some information from the staff about, you know, as these requests come in, what's the most difficult part and how can we get this done as quickly as possible so that we err on the side of transparency.
Trustee Stokebrand?
Yes, Trustee Bockhorst?
Yeah, I just wanted to make sure, how is this agenda sized? I thought it was a presentation, but if it is discussion as well, I just want to make sure we're not violating
it's discussion
open meetings law. About the presentation or policy?
Yeah, it's discussion on open records ordinance and policy.
Oh, okay. Thank you.
So I can speak from my department. I think some of the, you know, one of our big things that Attorney Silverman was able to answer was, you know, we get a lot of requests that are, we don't have the request, you know, the data for the request, but it's a question. But that could become an open-ended issue, right? So the questions could not stop, or they could be quite lengthy. And so how, you know, how do we handle that? Because we do want to, as a clerk customer service office, we want to be able to be as transparent as possible and provide that information. But we also run into, you know, a lot of those requests come at our peak times because, you know, if they're election requests, they come during election time. Our focus needs to really be, you know, running the election portion and setting that time frame. So that's one of the biggest ones. I think the other one that we run into is we can, you know, we don't have the record, but we could run a report in like 5 or 10 minutes and provide that information to people. It's not something we've created in the past or you know, need to create for any purpose, you know, doing a monthly review or anything, you know, is that, and I think that's where we'd like to hear from the board, is that something that the board wishes, you know, that staff spend their time on, you know, not dumping it and making it in, you know, spending hours upon hours putting it into a format that the requester may be easier for them, but that, you know, we can run a quick report. Something that comes to mind is people ask to know how many absentee ballots we have, and that's actually not a number that I can give to people unless I click the button to run the report. So people think that's, you know, something we just know off the top of our heads, and that's not actually true. We have to physically run the report. So those are two of the bigger questions. I think one thing for us, and it's just never going to go away, is we spend a lot of time redacting, and we just can't ever, you know, retain the cost for that, because you can't charge back for redacting, and redacting takes a lot of time. You know, so that's just, and we can't get around that. But it's just, I think, something for the board to understand that those are some of the requests that come through our office, that we can't always aren't as black and white, if that's helpful.
So in that kind of a situation, like what comes to my mind is a volunteer application where you've got, I don't know, it includes name, address, phone number.
Yes.
And I think, is everything up for grabs except, is the address redacted?
The address is typically public, but we redact the email and the phone numbers.
Oh, okay.
So yeah.
So if this was in a format that was not, I believe, if it was something like an Excel document and not a Word, could you do something so that you could automatically say, I don't want cell C11 included? I mean, is that the sort of thing where technology could save you time because you could just print out a document without that information?
You could. So something like the volunteer applications, because they sit on either a piece of paper or PDF, they want to see what people wrote on them. So we typically have to print them all out and then redact them. We don't redact with whiteout typically because people can chip it off. And so a lot of times we will redact with the darkest Sharpie or permanent marker we have, but if you hold it up, you can still see through that black line. So what we have to do is make a copy on the copy machine, darken the copy so that the redacted portion can't be seen. Now, granted, you know, someone's phone number and email is not quite as a big deal as something, you know, that the police department or other personal identifying information, you know, like an employee type stuff. But we also want to make sure, you know, that we aren't giving out people's information. But that's the type of stuff that takes us a good chunk of time.
Understood. Trustee Amenta?
Yeah, I mean, I think part of this, and it kind of dovetails with the police study, is thinking about what types of data we have and how it's stored. So for example, if we say, here's the writable PDF that you use to do your volunteer application, and that automatically goes to some kind of database, whereas Trustee Stokerbrand was saying you could very easily delete the two identifying, you know, it's like, why are we still doing stuff with paper? I mean, paper, if we weren't using paper anymore, and if we set up the databases in a way that potentially redactable information was in a separate cell or a separate field, then redaction would be easier. So, I mean, I think we have to look beyond just, well, this is how we do it now, and this is how we've always done it, so we have to do it this way forever, and look how much time it takes us. I think we have to start thinking a little bit more about how can we organize information in a different way in order to expedite or, you know, make public records more easily available at a less expenditure of time.
I guess that's kind of my point. Like, wouldn't I like to see who's all got an application, who's all got a volunteer application in the pool for, I believe the new policy is to do volunteer appointments in the spring. So wouldn't it be nice if you could just go online as a village resident and see who has all put an application in? I mean, shouldn't that all be public information? That's my.
Yep. So the portion that, you know, we have a spreadsheet of like who put their application in. The portion that people want to see is where they fill out their
narrative.
Yeah, and that is all, you know, they're typed fields, you know, into a PDF that we save.
And some of them are written in by hand.
Yeah, and some of are written by handing. So
yeah.
So if people just wanted the list, but if people were really looking to view their applications, you know, it's not, we don't use a system, we just use, you know, a fillable PDF. So it doesn't go into an actual database, that portion of it. It's all just sitting in individual applications.
And so I guess the question, are we ready to go to the next step? Whatever the next step is that would make that all more accessible, easier for you. Is that the kind of the direction we want to go is, and then if someone did come in and say, I don't have access to a computer, but I want to be on a committee, I'm guessing that doesn't happen much anymore, huh?
No, not really. You know, and it's something, you know, it's different technology that we're open to looking at. You know, and to that, just maybe more discussion of, you know, what is the requester looking for? Are they looking to view people's, you know, interest in what they want in something like that application, or are they just looking to see who is submitting applications, right? So I think, you know, part of it is maybe getting to residents of being very, if you're looking for something very specific, instead of being very broad when you make a request, you know, like somebody saying, I want all emails, you know, regarding, you know, whatever subject for 2 years. Well, is there something specific you're looking for? Because we can get that to you much faster.
Yeah. Trustee Ursink?
You know, I know this is probably one of just many issues like this in the village, and we've got 7 minutes here before our next meeting starts. What's, you know, what do we plan to do in the future? Is there a way we can get people, each department, to kind of break down what you know, what they'd like to see moving forward, or what would make open records easier going forward, so we can kind of look at all of that as in a bigger picture instead of just kind of focusing on this one volunteer application?
Yep, that would be good.
You know, I think, you know, Rebecca probably has, everybody here has a handful. So, you know, this, you know, so we should like, it'd be nice to get a big snapshot of the village and all the different, you know, issues like this that we can work together on.
Right. I just mentioned it as an example that came to mind, but I agree with you, Trustee Ursink. Anybody else? Trustee Amenta?
I mean, I specifically asked to get the number of requests and the amount of time it takes. And that's actually on the under agenda item discussion is what staff brought back to us. And the clerk doesn't know how much time it takes. About 40 requests are received. The police received 202 in 2020. So we know the number of requests, but we don't know the time or the cost to us to do it. I mean, you know, for me, I don't. It's not on the village to tell people how to structure their requests or to ask for little or not. I mean, whatever people, the information is public, it belongs to the public. Whatever they want to ask, and you know, they can ask. I think it becomes more a question. I think the issues we need to deal with are some of these issues that have happened, you know, in the last 40 years of data is in different formats and of use to people in a different way. And how do we accommodate that? And I think, the way we think about data and we store data, whether it's volunteer applications or police reports or whatever, as we've talked about in the context of the police study, we need to do some thinking about how we maintain data. And when we're doing that, how can we maintain data in a way that facilitates open records requests, because that will reduce, I mean, to me, looking at the billings that we have from the village attorney, it's a pretty sizable bill that we're paying for attorney services for open records requests, just attorney services, not counting anybody else on staff. So, you know, I really think we need to look at some of these technological issues. And another one that hasn't come up, but that people have mentioned to me, is access for people with disabilities, especially during COVID. You know, if we say, oh, okay, we'll give you a PDF, you know, here's a database with 20,000 pieces of information. We won't give you the Excel data. We'll give you a PDF with 20,000 things that you can now enter into an Excel spreadsheet, but maybe you're blind. How are you, but you know, I mean, so I know that those issues are not addressed in the public records law, but I think it's something we should be thinking about. So, and truthfully, I would like to have this discussion happen sooner rather than later, and have it be back to the board before the end of April, so this board can vote on this, because this is something that's been of interest to me for several years.
So is there any general policy direction, Trustee Carpenter?
I was wondering if Manager Ewald could kind of talk through time frame in making the policy changes, because it sounds like we have some consensus, you know, especially in relation to technology updates and things that have, you know, changed in the last 40 years or so. You know, we may have some other things that there may not be consensus on, but if we could, you know, I think there are several things that were discussed tonight that we could move forward with. Could we sort of figure out, you know, a timeline for the next meeting and how we move from here?
Sorry, I was on mute. So it's my understanding that this is going to be discussed at the next JP&L committee meeting, and that there are some members from the JP&L committee who are interested in drafting something. I know we briefly talked about technology tonight, but I'm not sure what policy direction was offered in terms of that tonight. We can have departments look at the data that they do have and how it started, and kind of bring you back a snapshot if that would make it easier, because each of those areas will be a bit different.
I think maybe if departments can give some clarity around the method that information can be sort of extracted, you know, whether that's, you know, Excel, PDF, Word, you know, so residents, you know, can maybe have that as an option. Sure. That might be helpful too.
Yeah, that would definitely be possible.
I wanted to lend my support to some of the things that have been said. I think our opportunity with this antiquated statute lies in updating some of the technology pieces on it. So I think that's where we start. We try to make it easier for people to get things in a form that's more easily digestible, helps, and kind of aligns with the purpose of these sunshine laws. So I just want to say I agreed and kind of lend my voice to the consensus here.
Trustee Ursing?
You know, it'd also be nice on top of that snapshot, if we were going to upgrade technology, to get any sort of price point to that. So if we wanted to, you know, move away from something we're doing now and we wanted to, you know, upgrade, it'd be great to see price points on that, sort of those upgrades.
I think it's fair to say that we would like to see, as you know, to Trustee Warren's point, I think unless someone raises their hand, I think we're all in favor of supporting as widely and as robustly as we can the sunshine laws and transparency. And I guess in my view, it'd be great to hear each department say what we think, what would make it easier for us to make public records more accessible, either in having them being done quickly, more comprehensively. But it sounds to me like we still have an issue to work out with the village attorney and documentation. Is that an understanding that other trustees share? The release of documents. I'm still not clear on a policy on changing anything that we're doing right now on that.
On releasing what documents are you talking about?
Documents that our attorney has, you know, if someone wants a document and as the custodian, the village attorney is not releasing the document.
You mean the village attorney's communications?
You know, it just seems that we have had issues with the village attorney and records coming out, and he is our custodian. And so I'm just wondering if that's still an issue that we need to work on at JP&L, or if that's something we're looking for guidance here from us tonight.
Well, he's not the custodian either. Sarah or I believe Chief Nimmer are the custodians.
Okay. Okay, anybody else? It's 7:31. I think it would probably, unless no one, does anybody else have a comment? Is there a motion to adjourn then?
So
I had a comment. My hand is up.
I'm afraid that it's 7:31 and we're late for a meeting already. And I believe you did speak earlier, Mr. Davidian. So we had a motion to adjourn and a second. All in favor?
Aye.
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 Thank you.
I think you got 3 ayes there.
Yeah, aye.
Okay, there's 4.
Sorry.
Aye.
All right, so we jumping off here and then going into the other link?
I'm voting no on the adjournment because we still had public comment. Thanks.
Actually, I'm going to change my vote to no as well. Thank you.
Okay, I have that recorded.
And I think it's a, what is it, 3, only 3 then?
I have four ayes and 2 nays.
Well, let's
so
hope.
You'll have to go to the next link for the board agenda.
Mr. Davidian, hopefully you can stick around to the our public comment.